It's Burnham B. Davis, and I live in Conway, New Hampshire. I have made. I was born September 13, 1908, and Conway, New Hampshire, has been the place where I've had my home all my life. I went to school at Kennett High School, from which I graduated in 1925, and I went to school at the University of New Hampshire, from which I graduated in 1929, and I graduated from the Boston University School of Law in 1938. My first work was for my father. He was a liveryman, which is an extinct species of business in this motorized age. And my first work was feeding and watering his horses and cleaning out the barn. After I graduated from college, I was a school teacher for 2 years at Thornton Academy in Saco, Maine. After that, I was a member of the legislature, and I was executive secretary for Governor Wynan, for a year and a third until the end of his term. And I was alumni secretary at the University of New Hampshire for a year and a half. The reason for this diversity is that I, rather stupidly, I'm afraid, ignored the existence of the Great Depression in 1931, and I gave up my teaching job and went to law school for 1 year. At the end of that year, I was without funds or employment. Wyman Boynton, who was with me, a member of the 1933 legislature, New Hampshire legislature, called us Coxey's Army. I recall having a conversation about that time in the Dover Railroad Station, where I was waiting for trains with Bill Grimes. Now that's William A. Grimes, noted American jurist from New Hampshire. But at that time, he was a student at the Boston University Law School, and I talked with him, and he expressed surprise that I would give up a good job teaching school to go to law school. I learned afterward what he meant. I learned painfully when I found myself floating high and dry, unemployed, with no prospect of employment. And then I read in the December issue of the Bar Journal for 1991, I read the interview that Bill had, in which it appeared that originally his plan had been for a career in business, and he'd been accepted at the Harvard Business School. And then apparently he was wiser than I, and he saw the dangers in going into business in the Depression. And so he changed his mind and went to law school. Considering his extremely high talents as a lawyer and a jurist, he's a former Chief Justice of the New Hampshire Supreme Court, that was an optimum decision for him to make at that time. When I first commenced the practice of law in Conway, there were here 4 lawyers. In Conway Village, there was Arthur Kennison Sr. He was Frank's father, and Roland Raspman. Raspman was a New York lawyer who came up here about 1940. He was a crack trial lawyer, and he had a big tort practice. And in North Conway, Arthur Green. Now, Arthur Green is the father and grandfather, respectively, of 2 prominent Manchester attorneys, one of whom is, I believe, still practicing there, and Harry Thompson. Now, Harry Thompson's distinguishing characteristic was his dry Yankee wit. If you spent much time with Harry, you spent it in mirthfully enjoying yourself. He was an enjoyable member of the New Hampshire Bar. In Ossipee, there was one lawyer, Preston Smart, and I think 3 in Wolfboro. We were all sole practitioners, including myself. Today, lawyers seem to tend to practice in clusters, but in those days we were sole practitioners. We were all in Conway alone now. there are 19 lawyers, and there are 67 in the county. We were all general practitioners. You might have a divorce case, or a suit on a promissory note, or a title search and report, or a will preparation, all in the same week or 10 days in those days. There was no specialization. I have been informed that there is a trend towards specialization in the urban areas today, but that trend has not been observable in this area in northern Carroll County. Discovery was rare or non-existent in those days. Recently, I heard the phrase trial by ambush. I have interpreted that to mean that you don't want your adversary to know what your evidence is going to be, so that you can prove some facts that he might not be aware of, and beat him that way. When I first started practicing law, that was accepted tactics. Now it is not recommended. I don't know where the line is drawn. Abraham Lincoln would not have won the famous Duff Armstrong murder case if he had been required to inform the prosecution in advance that he was going to prove by almanac that the moon set at 9 p.m. On the date when the witness for the prosecution, Allen, testified that he saw the murder committed at about 11 p.m. by the light of a full moon directly overhead. The years 1938 to 1941 were extraordinarily busy ones for me. In the first part of 1938, I was finishing my last semester of my law school, and after which I studied for the bar examinations and was admitted to the bar and was appointed to fill a vacancy in the office of County Solicitor of Carroll County. That's the office that they now call County Attorney. Upon my appointment, I was confronted with jury trials in an arson case, and a homicide case, and a statutory rape case involving most unsavory circumstances. I also was required to represent the county in a civil case involving a welfare situation. All of this, that 3 years, was altogether too brief a time for an inexperienced young attorney for whom everything always seemed to go hard. The salary of the county solicitor was $800 a year, and it was a part-time job. I had to earn my living outside of what I was doing, and here I was with these jury cases. Well, the arson case involved a wealthy woman in Sandwich who wasn't confident of her wealth. She set fire to her home. The fire department got there and prevented its complete destruction, but a good deal of damage was done. She was charged with arson, and Frank Kennison was then an assistant attorney general, and he came up from Concord, and he associated with me in the trial of the case, and he tried it so skillfully that she was convicted. She was a refined, well-educated woman, daughter of an admiral, and the evidence, as in all arson cases, was difficult. But Mr. Kennison conducted so adept a cross-examination that he caused her, or she caused herself, to be an undoubted perjurer. The jury had no choice. After she'd lied on the witness stand so openly, the jury just had to find her guilty of the arson. The homicide case was one that involved a man shooting a man in mistake for a deer. After 8 days of trial, the jury found him not guilty. I'm not ready to say that there was no reasonable doubt of his guilt. But the sheriff, the late James Welch, and Mr. Wentworth, the chief game warden, both were positive that the person charged was guilty. The statutory rape case involved a stepfather with a 13-year-old daughter of his wife. My trial of the case resulted in a hung jury. So we had to ask Mr. Kennison to come up again. And he tried the case, and on the second trial, the guy was found guilty, and he was sentenced to the state prison. The queer and interesting thing about that case is that 4 years later, after he'd served his term in the state prison, he came up to Conway, and he went at one noon. He came to my home and asked for me. I didn't know what to expect. I had said some very mean things about him in the trial. He wanted to see me to ask my advice on a legal point connected with his purchase of a car. He paid me my fee of $2. The rape case was not mentioned. The civil case was Belknap County versus Carroll County. Most of the people who were connected with the administration of welfare in the state in those days seemed to have the impression that in the case of a man who left one county and moved to another county, that is a welfare recipient who moved from one county to another county, he still remained the welfare recipient of the original county. And the original county was still responsible for assistance to him. Now, the man in question in this case, he had 2 children, and they were in foster homes in Carroll County. And he moved to Belknap County. The Belknap County thought that the rule that applied was the same the rule that applied in towns. In towns, a man would gain a settlement by living in a town for a certain period of time, but he couldn't gain a settlement if he was being assisted by another town. And so they thought the same rules applied to county cases. And the Belknap County commissioners did. And so they brought a suit against Carroll County. And we resisted the case and went to the Supreme Court. And the Supreme Court held that that Carroll County was not responsible. Now, the reason, but it did hold that the Carroll County was still responsible for the children, because the children still resided in Carroll County. And county, liability for county welfare depended wholly on residents. Not the settlement law did not apply to counties. Consequently, Belknap County was responsible for this man. Why? Because there was a statute in there that said that a man that the original county moved from was still responsible for him if he received assistance from the county moved to within 3 months of his first residence there in the county moved to. Well, the state agreed statement of facts, which we filed in the Supreme Court in this case, made it clear that he had been in Belknap County about 5 months before he applied for and received assistance. And so Carroll County is not liable, but still responsible for the children, to sum up. I suppose that my thinking on domestic violence cases is influenced by an experience that I had when I was county solicitor more than half a century ago. One Sunday afternoon, a deputy sheriff called me, and he said that a woman just outside of town had complained to him that her husband had battered her, and he wanted to know if I would go with him out there to see them. And we went out, and she had been battered all right. She had a very swollen and blackened eye. And the husband was there, and he admitted that he'd done it. And he said that he'd been working hard. It was a hot afternoon. He'd been plowing a field near his house, and everything seemed to go wrong. And finally his tractor broke down completely, and he had to give up. And he came home after a long afternoon, and he came in the house, and she said something fresh, and he let go and struck her. Well, he apologized to her, and he apologized to us for the sheriff and me for having to come out there, and he promised her that it wouldn't happen again, and she forgave him. End of case. No. About 3 nights later, the sheriff called me again. This time it was the husband who wanted us to come out, and he insisted that both of us should come. Well, we went. He was standing out in front of the house, and he pointed to a house about 50 yards down the road on the other side of the road, and he said, "Follow me." We followed him right through a ground floor window. First the outraged husband, next the deputy sheriff, and third the county solicitor. Somebody turned on the light, and there she was, in bed with a neighbor. The neighbor sat up and swung his feet out onto the floor and looked up at us and blinked and said, "Well, boys, I guess you got me this time." The Fourth Amendment was bypassed. The next day, the judge of the Conway District Court gave them both suspended sentences. And I think they were later married. Oscar Forum was a Dane who lived in Albany, a town adjoining Conway. He died in 1941. He hadn't been married, he had no children, and his rather considerable estate went to his brother, Mr. Charles Forum, who lived in Copenhagen. And I was appointed to administer the estate. I did so. I completed the administration. When the administration was completed, I had a fairly large sum of money in my hands. Meanwhile, the Germans had occupied Denmark, and I wasn't about to send that money to Mr. Charles Forum at that time. I held that money for about 4 or 5 years before I was sure that Denmark was out from under the German yoke. And then I paid the money to Mr. Charles Foreman through the United States Consular Service. Each year during that period, I got a polite letter in which Mr. Bedard, a lawyer in Washington, courteously inquired as to whether the estate's administration had been completed as yet. And each time I wrote to him and said that the estate was not yet in order for distribution. I am sure that Mr. Bedard realized what the situation was, and there was never any trouble and no problem, and I never heard from the thing again. Mr. Otto Johnson came to my office, 80 years old. He lived in Ossipee. He was a Swede. His name was originally Johansson, but he called himself Johnson here in the United States. He had come to this country in 1912. He had served in the American Expeditionary Force in France in World War I, and he'd been naturalized after the war. He left all of his assets to two people, a man and a woman, who lived in Sweden. I asked him, or he asked me to be the executor of the will, and I accepted that, but I asked him if there was any relationship, and he said yes, they were his children, but he had never been married to their mother. And he died about 2 years after that. And when they did, I investigated and found that he had more than $80,000 in savings accounts in local banks. And I contacted the Department of Revenue Administration, Mr. Kenneth Cowan, and Mr. Cowan asserted that the net estate was fully taxable. I resisted this because a statute, and it's Chapter 86 of RSA, Chapter 6, Chapter 86, Section 6, 2B, provides specifically in so many words that lineal descendants are exempt. His point was that they were not legitimate lineal descendants. And I pointed out to him that the statute mentioned nothing about legitimacy, and that it merely mentioned lineal descendants, and they were his lineal descendants. Well, I had to contact them, and I was able to do this with the help of a Mr. Carl Rottler, who lived in Conway. He was a Norwegian, but he had been captain of a ship that formerly did business with Swedish ports, and he could speak Swedish very well. And he translated the letters of these two children of Mr. Johnson. Now, the children were a boy, and they were a man and a woman. The man was a farmer, and the woman was a wife of a farmer. They were fine people. They wrote me nice letters. Mr. Rottler translated the letters for me, and finally I made a telephonic communication to their bank. They lived near Göteborg in Sweden, and they said that their bank, they wrote that their bank was the Bank of Göteborg, and that it had an English-speaking official, Mr. Larson. Well, I called up long distance, the bank, and of course it was a rather expensive telephone call, and I wasn't sure that it wouldn't be Mr. Larson's day off, and that I'd get on the other end of the line some Swedish-speaking people. But no, he was there. I got Mr. Rottler to sit in on a telephone extension, and Mr. Larson came on the phone. Cut. My voice is going. Mr. Larson came on the line, all right, and I introduced Mr. Rottler and explained that he was a Swedish-speaking person whom I had asked to help make the contact, and Mr. Larson's only comment was, "He's a Norwegian," because Mr. Rottler had given him a friendly greeting in Swedish, and he could tell from his accent, of course. He said he's a Norwegian, but he was very cooperative. I realized that there was going to be considerable expense involved in this case. I was determined to take the case to the Supreme Court. If the lower court should not accept my propositions about the exemption of the lineal descendants, I was prepared to take it to the Supreme Court, but of course that would make a lot of expense. It would reduce the size of the estate, and of course would reduce the amount of the tax, which is a percentage of the net estate. So I I made a proposition for compromise settlement to Mr. Cowan. I suggested that we split the difference. That is to say, that after the administration of the estate should be completed, that we would pay a tax on half of the net estate. He said he'd take it under consideration. And that was when I called Mr. Larson. And Mr. Larson contacted the beneficiaries, and they approved. And Mr. Cowan came back with an acceptance of my proposition, and the tax was settled on that basis. In the years 1942 to 1946, I was employed in Concord by the United States Office of Price Administration. The nation's leaders had determined that there was a serious threat to the nation's economy caused by the inflationary pressures which had been caused by the shortages brought on by the war. And the OPA, the Office of Price Administration, was set up for the purpose of keeping the nation on the economy of the nation on an even keel while we were fighting a war by curbing these inflationary pressures. The method employed was the issuance of a flood of regulations in Washington, having the force of law. The first of these regulations was the General Maximum Price Regulation, which we customarily refer to as the General Max, or the GMPR, or the Gumper. And this was followed by specific regulations applying specific ceiling prices to all commodities and services. These regulations provided penalties for anybody who should sell anything, goods, commodities, or services at a price exceeding the ceiling price. Now, the General Maximum Price Regulation froze all prices as of March 1942. But later, the regulations issued later worked out ceiling prices which were stated explicitly. The regulations were necessarily complicated and required a good deal of interpretation. There were about 75 to 100 personnel in the whole agency, the OPA agency, the office at Concord, and but that included the rationing division and the enforcement division, as well as the price division. The price division was headed by Mr. John Jameson, and had about 10 or a dozen businessmen, and later one woman who had acquired expertise in the pricing process in their businesses, and were enlisted for the OPA to apply themselves to the practical aspects of price regulation. They were very smart men. Some of these men were literally, actually geniuses, I thought. One of them predicted, now remember this was 1942, and one of them predicted that the day would come when the world would be swamped with, everything would be built of plastics. In 1942, that didn't seem possible. But as you know, plastics compose a good part of our life today. One of these men was an architect. That man became a good lawyer almost overnight, it seemed to me. He got so that he didn't require much supervision. He was very good in interpreting these regulations. Now, my duties consisted first in interpreting the regulations for inquirers from the public, including the mercantile public. By the mercantile public, of course, I mean the sellers. They were the people who were selling at certain prices. They were people the regulation applied to. And number two, my duties included interpreting the regulations for these businessmen who worked for the division. And number three included monitoring their replies that they gave to the public. I was required to scan a copy of each letter they wrote. And believe me, it took a good many hours of my time. And my fourth duty was conferring with Mr. Jameson. Now, Mr. Jameson was the most capable person I've ever known. He was a big, strong man, and he had a big mind and a very clear-thinking mind. He was director of the Price Division. Later on, when the directorship of the whole LPA division there in Concord became vacant, he was elevated to that job. But he continued as director of the Price Division. He directed the whole agency, but continued as director of the Price Division. I suppose that my great respect for Mr. Jameson was had as one of the contributing factors that I had learned that I was an avid sports fan, and I learned that he had been a varsity oarsman. He'd been a member of the Harvard crew, and of course that didn't help his status with. It didn't hurt his status with me. Oh, good God, darn it! Every interpretation that I gave to members of the public, including the mercantile public, and every interpretation that these businessmen, experts in our division, gave to the members of the public, including the mercantile public, was required to be confirmed in writing, with the copy being mailed to the OPA New England OPA regional office at Boston, where it was audited, and any errors in our letters were corrected by letters received from the OPA, New England OPA office in Boston. At first, it seemed to me that this was an inhibiting tangle, but it worked. This system worked. Not perfectly, but remarkably well. And the objectives and purposes for which the OPA was established were realized. A little sideline, one of the items to show how the OPA worked. There was one commodity which is well known, but not expected to be a candidate for price regulation. In the northeastern part of the United States in the winters, cordwood got into short supply, and the price of it escalated. And the escalation didn't stop with March 1942, and we had to spend a good deal of time on it. There was a period of time when there were many conferences, much telephoning back and forth between the Boston and Concord office, and much correspondence. And I would say that it's my recollection that during the next 4 years, the regulation, the ceiling price of cordwood per cord, the price per cord, was increased at least 3 times, and I would say probably 5 times. And this was an adaptation to the vagaries of a war economy. In the New England regional office at Boston, one of the attorneys had a favorite form of humor. It was the pun. And one day, a communication came to us reading something like this. We have accorded much attention to this problem. Please record that we are in accord with Concord with regard to cordwood. I represented a two-partnership attorney of accountants from Boston. They had rendered some services to a corporation which had a wood processing plant at Conway. And the plant closed. They rendered a bill and it wasn't paid. So they employed me. The first thing we did was to place an attachment by trustee process on an account which the corporation had at a local bank. The CEO of the corporation later told me that our timing was good, which I took to mean that it's entirely possible that they had intended to close out that account, and perhaps on the very day when our attachment beat them to it. These two accountants were very personable young men, about 35, 40 years of age, and they were very articulate. They were very good witnesses. And the trial took place at Ossipee in the Superior Court. It was presided over by the Chief Justice John R. Goodnow. And these witnesses testified, and they described the work they'd done, and they filed the documentary evidence, which was filed as an exhibit in the case, and they proved a good case. The only thing that was lacking was we had to prove the fair market value of their services. Now, they were not CPAs, but John Rich and Alfred Hartford in Concord were CPAs, and they came up to Concord, and they qualified as expert witnesses, and they testified and gave their opinions of the value of this work. They examined the exhibits, which were in a bundle of papers on file with the clerk, and they talked with my clients, and they testified very thoroughly and gave opinions as to the value of the work. A verdict was rendered for the full amount of the claim. One afternoon, about 5 o'clock, my telephone rang, and it was a friend of mine calling me from the police station in North Conway. Burnham, they're saying that I've been having sex with my daughter. I want you for my lawyer. I told him that I'd have to talk with him first, and I got him in the office the next day. And I told him that there were plenty of lawyers who would take his case whether he was guilty or innocent, but I was not one of them. I didn't ever take cases when I thought there was a doubt about the defendant's guilt. And I said that if I should decide to take his case, and at some time in the proceedings, I should become convinced that he was lying and that he was guilty, I would immediately withdraw from the case. And he should be warned that if that happened, probably the court and the jury would draw the conclusion that he was guilty. Now, of course, I wouldn't be allowed to withdraw from a case at least after the jury was drawn. But he didn't know it. I knew it, but he didn't know it. And so I thought that I would try to jolt him into coming clean with me in regard to the case, whether he was guilty or innocent. He still protested his innocence. he still said he would have no other lawyer. Now, this was a matter of mystery to me. I didn't have any reputation as a criminal lawyer. I didn't really have any reputation as a trial lawyer in any field. And I never could understand as to why he insisted on having me for his lawyer. But he did. I talked with his brother, and his brother had the same problem I had. But he said he said he didn't know any reason that his brother wouldn't be telling the truth about the case. Finally, I decided to take his case. The compelling reason was that he had a letter from his son, who was in the Navy, and he wrote a letter to his father, and he said he was sure his sister was mistaken. The son was 19 years of age at that time. The girl was 18. He came, he got leave from the Navy, and he came and he testified clearly and convincingly in the case. There was the further circumstance that sitting in the courtroom was the girl's mother, who was the divorced wife of the defendant. When they were divorced, she had gotten the custody of the daughter, and she attended the trial. But she sat there and listened to him, and he testified on the witness stand that as a result of something that occurred between them back when they were living together, he had something drastic had happened to her, and she had told him that she would get even with him someday. Now, she didn't deny this. She didn't take the witness stand. She didn't even react. She didn't at any time show any objection to this statement that he made. There was another woman who testified who had occupied an apartment adjoining the one occupied by this family during the period when the alleged criminal activities, incidents had occurred. And she said that this young girl had become very friendly with her and had come to visit her very often in her apartment and had made a confidant of her, had told her many of the intimate details of the girl's life, and had asked her advice on many things, and never once had mentioned anything of this sort, or any doubt about, or anything to inspire doubt about the conduct of the father. There was other evidence. Of course, a good deal was said about reasonable doubt, and the jury acquitted him. Now, one day in the late 1940s, an 87-year-old in the latter part of the 1940s, I was contacted by an 87-year-old gentleman who asked me to prepare his will. When I use the word gentleman to describe this man, I am giving a strictly accurate description. He was a gentleman in several senses. It has been said that the chief attribute of a gentleman is gentleness. He was an illustration of this. Tall and thin, white hair, and always wore a blue serge suit. As a matter of fact, his face is long and thin. He always put me in mind of a Roman senator. He spoke firmly and quietly, and he was courteous to the point of courtliness. But now this gentleman, he was frail appearing, 87 years old, but he was a strong, tough individual. Shortly before, sometime before the will conference, he had sold his hotel, and he'd come to me and ask me to help him with making up his income tax report of the capital gain on the sale. Now, he built that hotel in 1879, and he'd operated a successful summer hotel until about 25 years ago, when he had retired and closed the hotel. It had been closed ever since. And he finally succeeded in selling it sometime in the 40s. I don't remember just when it was, but it was in the 40s. And he had to report it for income tax. And he sat in my office 4 solid hours, one hot summer afternoon, adding up the figures, the undepreciated figures that for the construction of the hotel and the improvements that have been made on that since that time. He remembered what the improvements were. He remembered in detail everything that was done. But he didn't remember the figures. He didn't have a scrap of records. And he had to estimate most of the figures. But when he did, he made it careful. He was careful to state, and it was included in the income tax return, that these were estimates, that they were not the actual figures. And so he estimated them. It was really a sort of a guesswork. Well, he died a couple of years later, and there was, of course, trouble with the IRS. And the son and I had to go to Portsmouth, which was where the district office of the IRS was at that time located. And we had to go to Portsmouth to confer with some 2 accountants representing the IRS. And I thought the son couldn't understand my eagerness for compromise. Didn't understand why we should compromise at all. He never could reconcile himself to the fact that we had to pay some extra tax. Well, I thought the IRS representatives were very fair with us. They accepted more of the gentleman's guesswork than I expected they would. And but the son thought that they should have accepted it all. Conway District Court was one of the activities that I engaged in, and the most interesting and valuable part of the work of the Conway District Court was the juvenile delinquency cases. They took up a good deal of the time of the court. Now, the key of a juvenile delinquency case is a good probation officer, and that means a caring, thoughtful, hard-working individual who understands, who likes children, likes young people, and tries to help them rather than to punish them or hurt them. And there was a period of several months when the Conway District Court had no probation officer at all. And then we had got some help from a minister of a local church, and we got some help from the court's clerk's husband was a local contractor, and he gave some of his spare time to counseling and monitoring these young people. But one day, the police came to me with 17 separate cases of juvenile delinquency, 17 young people. And it was just too much. And but it did so happen that just about that time, I met Mr. John P. McVitie. Now, Mr. McVitie had been a lieutenant in the police department of White Plains, New York. And he had retired. He'd reached retirement age. He was about 67 or 8 years old. He'd retired, and he bought a home in Eaton Center, about 5 miles from Conway. And I asked him, and he didn't say no. And I went to the telephone, and I called up Mr. Richard Smith, who is the director of the probation department in Concord. And Mr. Smith came up to Conway that afternoon and went to see Mr. McVitie and signed him up. Well, it was the solution of our problem. Mr. McVitie knew how to handle children. He loved children. He loved young people. He was a tough guy. He didn't stand for any nonsense with them. One of those juvenile delinquents was a big, powerful guy, bigger than Mr. McVitie. But Mr. McVitie was a muscular man, and he just took him by the shoulders and sat him down in a chair in my office, and the boy quieted right down. The only drawback to having Mr. McVitie as a professional probation officer was that after he had served us for about 3 or 4 months, the selectmen of the town drafted him for chief of police. But by that time, the probation department had enlisted the services of a young man, Mr. Paul Croteau, and had sent him up to serve this court as probation officer. Stop it. God damn. An attorney in a situation of this sort, an attorney reviewing his past work, usually carefully skirts the cases he lost. I am not prepared to depart from this time-honored custom. I don't recall turning down any cases. I didn't make much money, but I learned a lot. In the cases involving considerable amounts of money, I procured Richard Upton to try the cases for me with my assistance, what little assistance I could give in the preparation of the case. And these were primarily, for example, automobile accident cases, and also the eminent domain cases. There was a lot of highway work going on at that time, and the state was taking a good deal of land by eminent domain for highway purposes. And Mr. Repton represented my clients, and he didn't get much help from me, but I gave him what I could. But he was very skillful. And I want to say this, that Mr. Upton must have handled at least a dozen or probably more cases in the next 30 years. And in every single case he handled for me, we received either a satisfactory settlement, out-of-court settlement, or a satisfactory jury verdict. And that was satisfactory to me and satisfactory to my clients. Mr. Upton is just a real excellent trial lawyer. Now, cut. I tried one of these cases myself alone. I had a particular chum in Conway, some of whose land was taken by the state under the power of eminent domain for a part of one end of the Kankamogus Highway. The eminent domain cases involved the value of the land, in that the law required the state, when it took it, it had a right to take any land it wanted to. But if it took the land, it had to make fair compensation to the owner. So when they took it, they would make an offer to the owner. And the offers weren't satisfactory. And that's where Mr. Upton came in. He tried the case and obtained a jury verdict of a considerably higher amount. in damages for the eminent domain taking. And I tried this case. My friend authorized me to go ahead. And I got a verdict of $4,800. It was much more than he'd paid for the land, and he was perfectly satisfied. And there was another case in which we had a witness who, this was one of the cases that Mr. Upton tried. And this witness was himself a realtor, but he owned a lot of land. He frequently bought and sold land. And a man who buys and sells land knows quite a lot about the value of land, which was the big issue in these eminent domain cases. And when he testified, he was French. He could speak no English when he first went to school. He was born in Conway. When he first went to school here in the first grade, he didn't speak any English. He later got so he spoke English, and by the time he was serving as a realtor here in town, he spoke English without any accent. But he wasn't well read in English. And I think that the state's attorney thought that he had sort of a pushover for cross-examination. And so he asked him a question. Sir, weren't most of these cases more or less hypothetical? And the witness, the word hypothetical was way back in the Greek city-states as far as he was concerned. He'd never heard of the word. But he gave a good answer. He looked the attorney in the eye and he said, I want to tell you something. I didn't have much schooling, and some of the words you use mix me up. But I have bought and sold millions of dollars worth of real estate, and I think I know what a piece of real estate will bring in the market. Now that I've told that story, I realized that I must make a correction of it. I was recalling these things in the 90s. In the 90s, we talk about millions, a good deal. But this occurred 35 years ago. And I don't think he said, I have bought and sold millions of dollars worth of real estate. I think he said, I have bought and sold thousands of dollars of real estate. But in thinking of it in the 90s, I remembered it as millions. And I think I was mistaken about that. In conclusion of my remarks, I would like to give a comment on the televised O.J. Simpson trial. My comment has to do with the fact that I believe that the way in which that televised trial did harm to the legal profession was that in it enlarged and spread the already widespread belief that if you pay a lot of money for lawyers, if you committed a crime, your chances of getting away with it were in direct proportion to the amount of money that you paid for legal representation. And the O.J. Simpson trial, it was already widespread, that belief. But I want to mention, give another opinion. My opinion is that the New Hampshire Bar Association and in the state has done outstanding work in the correction of this impression. But I'm still gloomy about the prospect. I don't know what is being done in other states. But I think that the activity in this state although highly commendable and probably as good as or better than that in any other state, is still an uphill job. Laymen have for many years had this opinion of lawyers. Chief Justice Berger at one time made the remark that we may be well on our way into a society overrun by hordes of lawyers, all hungry as locusts. And the ordinary layman has believed for a long time, since way before Shakespeare's day. One of the characters in one of Shakespeare's play says the first thing we will do is kill all the lawyers. But from now on, and over and over again, I think that we will find that they will cherish as a truism that if you pay a lot of money for lawyers, it's a kind of insurance against consequences. Cut.
That was the
I had a good. I think that the variety in time and range of the business, the contacts, are such that a country law practice is a sort of microcosm of life in our times. Rich man, poor man, beggar man, thief, doctor, lawyer. I had a Native American as a witness one time, but he didn't make chief. I have had 58 years of it. And looking back, I recall some of the up times and some of the down times and some of the in-between times. There has been much after midnight work. There have been frustrations. I don't recall any boredom. The man behind the 8-ball is never bored. But the country lawyer is almost always in a constant fever about getting done his work because there's somebody that needs it and is expecting him to have it done. And